beyond debate. And what seems to me is what you're describing are things that different fact finders can weigh differently as to what was reasonable or not.
I disagree respectfully, Your Honor, and I'm sorry I did not tell the court, but I would like to reserve a few minutes for rebuttal, if possible. I appreciate what you're saying, but I respectfully disagree, because where is the case telling Officer Dunn here that he should have released that dog any sooner than he did?
Watkins.
But Watkins is substantially different. In Watkins, the officer was already in the room, had a view of the plaintiff, went hands-on with him, and again, had other officers just standing around. Those are not the facts of this case. They are substantially dissimilar and certainly would not warrant the denial of qualified immunity under the Supreme Court standard.
Okay, do you want to reserve?
I would like to reserve. Thank you, Your Honor.
Good morning, Your Honors, and may it please the court. Fulvio Quina for Appellate, Mr. Rosenbaum. We want to start off by addressing the Watkins case, which we do believe has put all officers of the Ninth Circuit on notice that a bite of an excessive duration.
Is it true in Watkins, and I just don't recall, he was not handcuffed before they released the dog? Is that correct?
Absolutely, Your Honor. He was not handcuffed.
And the reason why that's important to me is Mendoza does suggest that, it was okay. I mean, in Mendoza, we held that it was okay to keep the bite until he was handcuffed, until the defendant was handcuffed, and, or I guess plaintiff, depending on which case you're looking at. And so Watkins seems to backtrack from that and say, well, I mean, if Mendoza was just out there, I think they probably would be entitled to qualified immunity. Would you agree with that?
I would agree with that. The Mendoza case, Your Honor, came out in 1994. There, almost as in dicta, the court said, well, if someone were to be handcuffed and on the ground, you obviously wouldn't be able to sick a dog on them. Watkins actually addresses the point more clearly, and there the Watkins court said, if someone is helpless and surrounded by officers with guns drawn, where the suspect has surrendered and is under control, then you can't continue a dog bite. So they remove the element of needing to have handcuffs.
So what about what do we do with the factual differences between Watkins in this case? Because the city makes a good argument that it was different. There was more of a sense of control, I think it's fair to say, in Watkins than there was here. Maybe you may disagree with me, or at least more of a sense to observe it. And I guess part of that, maybe you can explain to me exactly what your position is on how much time, because it is true there was 20 seconds between when he was on the ground, but at what point was Officer Dunn actually there to see it and observe him? How long did the bite last?
All right, first off, I'd like to say that we believe our case is much stronger than Watkins. In Watkins, the court held that the dog bite was unconstitutional in a situation where the officers alleged that they couldn't see the suspect's hands. Here, in our excerpt of Record 26, which is the video that is on Officer Dunn's body camera.
They could see it from the beginning.
You can see his hands throughout. His hands were never, ever hidden from the officers. With respect to, whether...
Can I just quickly follow up on one point? Is there any question whether the officers knew that Mr. Rosenbaum was unarmed or armed by the time they were up there nearby him?
Yes, Your Honor. As a matter of fact, in excerpt of Record 41, which is my deposition of Officer Dunn, I asked him, isn't it true that the fiancé actually informed you that Mr. Rosenbaum's firearms had burned in the Santa Rosa fires? And he agreed that had been relayed to him. So with respect to at least to firearms...
Oh, I'm not really referring so much to that as... is there any indication that the officers thought once they're up there near him physically that he might still be unarmed? If I recall from the video, he was wearing something that would suggest that clothing wouldn't obscure whether he had a firearm with him.
He had a tank top on.
Right.
He had a tank top on. And to go back to the video, to ER 26, Officer Dunn deploys a canine at 10:36 on the video, 10 minutes and 36 seconds. He issues the command, which I won't say here, and the dog goes up the video. Officer Dunn, again, just relying on the body cam. And remember, the body cam is set lower than Officer Dunn's eyes. So he's going upstairs. Presumably he can see before the body cam can see.
I was going to ask just factually, is there anything in the record to indicate that the officer had a different view than the body cam he was wearing?
No, Your Honor. The fact of the matter is that at his deposition, he testified that, yes, the body cam is chest worn. So when he arrived to the landing at 10:51, we can see on the body cam, and presumably Officer Dunn can see as well, that Mr. Rosenbaum is in a seated position on the ground with the dog latched onto his arm. Immediately thereafter, Mr. Rosenbaum goes onto his belly, arms outstretched. And from 10:51 through 11:19, nearly 30 seconds, the bite continues. At 11:19 is when Officer Dunn issues the order for release. The entire time, Mr. Rosenbaum's arms are outstretched and in front of him, and he's in a prone position.
Does he ever try to stand up?
No, Your Honor. He never tries to stand up. And we have to remember, unlike in Watkins, I guess, not only is Mr. Rosenbaum completely surrounded by officers up there, and again, this notion that Officer Dunn is on the staircase is belied by the body camera. The body camera shows that Officer Dunn is on the second floor when he releases the dog. And Mr. Rosenbaum is surrounded by officers. The house is surrounded by officers. There's a chopper in the sky surrounding the house. I mean, he couldn't have been more controlled. And unlike
that only goes so far. I mean, if there was a weapon there, the fact that there was no escape didn't mean that the officers themselves wouldn't have faced some harm. So, I mean, I don't think the chopper indicates control. I think your argument for control, or certainly at least a factual dispute on control, is the fact that he was prone on the ground and the dog was biting him. And that's why I'm asking. I don't mean to shift gears so much, but you agree, I guess based on how the city's arguing, I don't understand, honestly, how the other officers can even be held liable here. It seems to me that if you have one officer who's in charge of the dog, you cannot rely on another officer to release the dog. And if they didn't have any opportunity to release the dog, now I know the district court held differently. Is that on appeal to us at all? Can we deny qualified immunity to Officer Dunn, but grant qualified immunity to the others?
That argument's not before the court. Our position is that it's been waived. We didn't even brief it because it wasn't in the appellant's moving papers.
I think that's right, and I'm sort of shocked that it hasn't been briefed. It seems like a huge miss for these other officers. So, anyway, keep going.
Yes, and then
I guess I have one question that I'm sort of trying to puzzle through, and that is, the rule is that once somebody has surrendered and is under control, then you've got to let the dog go. There is a timing factor there, right? So that can happen on second 5, and then there's got to be some sort of period of time for an officer to recognize those are the circumstances. I need to call off the dog. Is that something that timing, I guess twofold. Is there any evidence to indicate that we should be thinking about that in this case, that the officer somehow didn't understand those were the circumstances, or that he was having a perception problem?
No, there's no such facts that there was a perception problem. But going to the timing, again, I wanted to follow up on what Judge Sanchez said about the Miller case, the Miller v. Clark County. In that case, and it's procedurally, the posture is different from our case, but in that case, the court found that there was no unlawful acts by the officers because they released the dog immediately. Here, nearly 30 seconds go by. That's an eternity while you have a dog causing the kind of damage.
So that's your position, is that because of the time frame here, we don't really even need to wrestle with that because it's just too long?
Yes.
Well, but you say 30 seconds, but I don't think it's 30 seconds from when he was under control. I mean, I guess that's the question we have to grapple with, and maybe we only need to grapple with it so far as to say it's a factual dispute that, at what point he became under control. But at what point after Officer Dunn got to the top of the stairs, how much longer did the dog bite go? Or do we know? Or that's a factual dispute?
Our position is that from the 10:51 mark through 11:19, that's the time that Mr. Rosenbaum is prone, arms
So you
outstretched.
think there's 27 seconds where he was prone on the ground, Officer Dunn could observe him prone on the ground?
Yes. And this is from the body camera.
I was going to say, to me, I think that the important point here is about our interlocutory review, is because we have to credit plaintiff's allegations as true unless they are plainly contradicted by the video evidence under Scott versus Harris.
Correct.
And as I understand your complaint, or the plaintiff's complaint, plaintiff alleges that he had fully surrendered and hands were outstretched while surrounded with all the defendants with their firearms, but the dog was allowed to continue biting him for over 20 seconds before, and that is enough. Just passing that 20-second threshold was enough to be excessive force. So whether it ends up being 25 seconds, 20 seconds, 30 seconds, whatever a trial would establish, that's enough to establish a constitutional violation, and the video doesn't contradict it.
Yes, that's our position, and our further position is that the district court got it right. At the very least, this is a tribal issue of fact for the jury to determine at this point. But as to the purely legal question of were the officers on notice, we think Watkins puts them squarely on notice. No further questions that we submit, Your Honor.
Okay, thank you.
Thank you.
Thank you, Your Honors. I want to go back to the issue or the standard here of having the suspect fully surrendered and fully under control. And what this appeal is actually about, which is there a case that would have informed Officer Dunn that Mr. Rosenbaum was fully surrendered and under control in this scenario? And the answer is no. The court has never defined what that means in this context. And for that reason, Officer Dunn is entitled to qualified immunity. Watkins is not that case. The facts of Watkins are substantially different. At most, what we can take from Watkins is that an officer cannot stand idly by with their guns drawn, giving commands that the plaintiff cannot comply with, because that was another important factor in Watkins. Those are not the facts of this case. And so for that reason, Officer Dunn is entitled to qualified immunity, and the other officers are as well if he is found not to be liable here. Thank you, Your Honor. Submitted.
Thank you. Thank you to both counsel for your arguments in the case, and the case is now submitted.